Hey guys. Welcome back. Today's video is absolutely insane. We're exposing not one, but TWO sovereign citizens who somehow managed to outdo each other in pure courtroom stupidity. The first is a complete lunatic accused of stabbing a police officer while claiming he's an actual king, because apparently being royalty now means the law doesn't apply to you. And the second is someone you may already recognize from a previous video, William Sullivan, the possible long-lost Brunkle of Jared Sullivan. Now, I can't officially confirm they're related, but let's just say the matching last names, similar appearance, and identical brain-melting arguments make it feel way too suspicious to be a coincidence. I'll leave the previous video linked below so you can judge for yourselves. Trust me, this one gets ridiculous fast, so let's jump right into it.
Mr. Halpern.
Thanks, Judge. This is Mr. Montez, number 36.
22 CR 7002, People versus Montez. Entries?
Daniel Cohen on behalf of the people.
And Robert Halpern on behalf of Mr. Montez, who is present in custody in the courtroom today.
All right, we're set for sentencing today.
That's correct.
Ready to proceed?
Yes.
Yes, Your Honor.
Prosecution?
Thank you, Your Honor. I will just initially note, well, as the court is aware, this is a case that it's a fairly small range of sentencing between 20 and 25 years. I am going to be asking for the 25 years. I believe
it was, did I typo? I thought it was 24.
Sorry, 2024, pardon me. That was the older. The previous one was 2024. I'm asking for that 24 years. I know, I think we're all aware of Mr. Montez's situation, but at the end of the day, this was a very violent assault against peace officers when they were trying to enforce the law and protect the peace and sanctity of the Denver Union Station bus station. As someone who has regularly used that bus station, I know how harrowing it can be at times. And I know the amount of work that RTD has put into that to try and make the public transportation system safer in this city. It's necessary for so many people, and for some of us, we want this RTD to be safe and enjoyable for everyone. And Mr. Montez, through his actions, severely disrupted that. And I believe that based on the nature of his offense, he has earned those 24 years. I will say that in preparing for this trial, in speaking to some of the witnesses, one witness, what stood out in my mind is when I asked him, what did you think when you saw what happened? He told me, my first thought was I just lost a colleague, because the stabbing was just that violent and aggressive. And thankfully, the officer who was stabbed repeatedly in this case, his vest did exactly what we hoped it would do. It prevented him from receiving any further serious injuries. It prevented him from being killed. But there were lasting effects in this case. The officer whose hand got cut suffered a fairly severe infection as a result of that, and is, I believe, still on desk duty as a result of that. His hand has never really gotten back to full functioning. This has affected a lot of people in a lot of different ways. There's a very large restitution amount, and I don't know if I haven't had a chance to talk to Mr. Halpern about this, so I will state that it's in excess of $20,000. So if I could have an opportunity to file a written motion, because it's divided between multiple different officers and expenses. So if I could have permission to file a written restitution request after conferring with Mr. Halpern about it, and I can get that done in the next week to week and a half.
To be heard before sentence.
So now he's facing up to 24 years in prison for assaulting a police officer at a bus stop. His attorney is clearly trying everything possible to reduce the damage and convince the court to show some level of mercy. But unfortunately for the defense, the self-proclaimed, diplomatically protected king is about to do what sovereign citizens always do best: open his mouth, ignore reality, and completely destroy any remaining hope of a lighter sentence within seconds.
Thanks, Judge. It's been a difficult case. It's obviously quite old, and I've gotten to know Mr. Montez throughout the pendency of the case fairly well, and I know he would disagree with some of my characterizations and my raising competency, but I've seen kind of the highs and lows, if you will, and when he is what I think functioning on a competent level, he's very smart, asks really intelligent questions about the case, about his options, about what happened that day, and he's taken responsibility for it. And it was, you watch the video, and that part of it is hard to watch when he has the scissors, but there is a long standoff, and that's in front of an elevator.
I watched the video.
Okay. And what Mr. Montes is talking about, and you hear it on the video, is at some point they do say that he can go. Once he puts the scissors away, they wanted him to get rid of the scissors, and then the doors open, and he did think he was free to go, and he got rushed. I think it's pretty clear that they weren't going to let him go given the circumstances, but he believed that and stepped back onto the elevator, and then they rushed him, and he reacted. And again, it's scary watching that reaction, and I'm glad they were wearing the vests. And I'm also glad that Mr. Montes, before the trial, opted for this option. While it's still a hefty sentence he's looking at, I would be concerned about post-trial and what he'd be looking at potentially the rest of his life. Again, I'm not sure that Mr. Montes, to this day, agrees with the idea of mental illness and mental health. But again, I think when I've seen him on his medications and doing well, he is smart and thoughtful. And I would encourage him to wrap his head around that and understand that diagnosis. Obviously, that's a decision he's going to make. But when I've seen him at his best, he has a lot to offer, and I really wish him luck moving forward through the prison, and then when he's released, and how he handles that in the future. But I know he wants to speak, and I do wish him the best throughout this process.
All right, sir, you have the right to tell me anything you'd like me to know about this case and what your sentence could be. I really have no interest in anything else. The only issue for this court is what should the sentence be?
All right, this is very important about the case and about the sentencing. Very important that my diplomatic immunity, highest degree, was automatically uploaded and in effect February 2023. It will be against my rights as a king and diplomatic immunity to prosecute me. Protocol. I am a king.
We've passed all that, sir. You agreed to plead guilty. The only question right now is, will I give you 20 years or 24 years? That's what you agreed to. So what is it you want? 20, 21, 24?
With diplomatic immunity, highest degree, is what I'm trying to understand is that I'm not supposed to be prosecuted. So how is it?
All right, that we're not having this discussion anymore, sir. You need to talk to me about the sentence.
At least.
Your record has been made. You have no diplomatic immunity. I'm sentencing you to 24 years in the Department of Corrections. There's a 3-year period of mandatory parole, and I will give you, what's his pre-sentence confinement credit?
1,043 days.
1,043 days of pre-sentence confinement credit, and we will determine restitution within 63 days. Good luck, sir.
At this point, the video might as well be called When the Self-Proclaimed Court King Becomes the Jailhouse Jester. What started with delusions of power ended with complete humiliation in front of the entire courtroom. And before we move on, huge respect to the officers and public servants who put themselves on the line to protect our communities every single day. I genuinely hope the officer involved in this attack makes a full and speedy recovery. But now, it's time to shift gears and head into Bronnell's courtroom appearance, where somehow, the chaos only gets worse.
Call case number 2025 M534, People of the State of Colorado versus William Sullivan. Good morning, Mr. Sullivan. Okay.
I'd like the record show, Your Honor, that my name is William Sullivan. I'm the living man. I'm not the entity known as William Joseph Sullivan. So, and I'd like to know the nature and cause of the charges that I'm here for today. I'm under threat, duress, and coercion.
Okay.
So, yes, sir.
Okay. Well, Mr. Sullivan, you're charged with a violation of Colorado Revised Statute, Section 42-4-1409, subsection 1. This is no insurance by an owner. In order to be found guilty of this offense, the state would need to prove beyond a reasonable doubt that you owned a motor vehicle or low-power scooter that was required to be registered in the state of Colorado, and you operated the vehicle or permitted it to be operated on a public highway in Colorado without a complying policy or certificate of self-insurance in full force and effect as required by law. This is a Class 1 misdemeanor traffic offense. It carries a mandatory fine of $500. Half of that fine could be suspended upon a showing that insurance has been obtained. If it's your second or subsequent conviction within a period of 5 years, it could result in a fine of not less than $1,000. You're also charged with a violation of Colorado Revised Statute, Section 42-4-1402, subsection 1 and subsection 2A. This is careless driving. In order to be found guilty of this offense, the state would need to prove beyond a reasonable doubt that you drove a motor vehicle, bicycle, electrical assisted bicycle, electric scooter, or low-power scooter in a careless and imprudent manner without due regard for the width, grade, curves, corners, traffic, and use of streets and highways in all of their attendant circumstances. This is a Class 2 misdemeanor traffic offense. If found guilty, it carries a penalty of a fine between 10 and 90 days in jail, or a jail sentence of between 10 and 90 days in jail, a fine of between $150 to $300, and 4 points could be assessed against your driving privileges. You're also charged with a violation of Colorado Revised Statute, Section 42-4-1605. This is leaving the scene of an accident involving a highway fixture. In order to be found guilty of this offense, the state would need to prove beyond a reasonable doubt that you were driving a vehicle that was involved in an accident that resulted in only damage to a highway fixture or traffic control device, and you failed to notify the road authority in charge of such property of the accident and your name, address, and registration number of your vehicle. This is a Class 2 misdemeanor traffic offense. If found guilty, you could be sentenced to 10 to 90 days in jail. You could be fined an amount of $150 to $300. You're also charged with a violation of Colorado Revised Statute, Section 42-4-1606, subsection 1. This is failing to report an accident and call police. In order to be found guilty of this offense, the state would need to prove beyond a reasonable doubt that you drove a vehicle that was involved in a traffic accident that resulted in injury to, serious bodily injury to, or death of any person, or resulted in any property damage, and you failed to give immediate notice of the location of the accident to the nearest office of the duly authorized police authority, or you failed to immediately return to and remain at the scene of the accident until police arrived and completed their investigation. This is a Class 2 misdemeanor traffic offense. It carries a penalty of 10 to 90 days in jail, a fine of $150 to $300. 12 points could be assessed against your driving privileges, and your license could be suspended. You're also charged with a violation of Colorado Revised Statute, Section 18-9-107, subsection 1A. This is obstructing a highway or other passageway. In order to be found guilty of this offense, the state would need to prove beyond a reasonable doubt that without legal privilege, you knowingly or recklessly obstructed a highway, street, sidewalk, railway, waterway, building entrance, elevator, aisle, stairway, or hallway to which the public or a substantial group of the public had access, or you obstructed any other place used for the passage of persons, vehicles, or conveyances. And it doesn't matter whether the obstruction arose from you acting alone or from your acts in conglomeration with the acts of others. This is a petty offense. If found guilty, you could be sentenced to up to 10 days in jail and fined an amount of up to $300. You're also charged with a violation of Colorado Revised Statute, Section 42-2-206, subsection 1A. This is driving under revocation. In order to be found guilty of this offense, the state would need to prove beyond a reasonable doubt that you operated a motor vehicle in the state of Colorado at a time at which your driving privileges were revoked. This is a Class 2 misdemeanor traffic offense. It carries a fine of between $150 to $300 and 10 to 90 days in jail.
So he's facing the classic sovereign citizen, traveler, trifecta of charges, along with allegedly smashing into highway equipment and failing to report it to police afterward. In other words, this sounds less like a peaceful traveler exercising his rights, and more like someone who may have been hitting the bottle a little too hard before getting behind the wheel. Because when you combine reckless behavior, bizarre excuses, and a refusal to take responsibility, you end up with exactly this kind of courtroom disaster.
So those are the charges against you, Mr. Sullivan. At this point, At this point, are you wishing to apply for a public defender? Are you going to represent yourself?
No, sir. Again, Your Honor, like I said, I'm the living man. I'm not the corporate entity, the fictional entity, William Joseph Sullivan. I need to know, is this a civil procedure or a criminal procedure against me?
This is a criminal proceeding,
It's a
Mr.
criminal
Sullivan.
procedure against me. Let the record show this is a criminal procedure against me. Could you give this to Your Honor? This is a judicial demand, a rule of nisi.
If you want to bring that up, I'll
Present that
take a
to
look
you.
at it.
Your Honor, please. Stating that I be recognized as a living man, as stated in the Bible. You're either a man, a woman, or a citizen. I'm not a second-rate citizen. I'm not a corporate fiction. Unless the DA or the court can prove to me I'm a corporate fiction, but I stand here as a living, breathing man. Also have a motion for dismissal. If this is a criminal case against me, then I have the right to face my accuser. I need to know who that is. I need to see a written affidavit from that person, and I have the right to face them if this is a criminal case.
Do you have a copy of that motion, Mr. Sullivan?
I do right here.
Okay, why don't you bring that up as well?
Apologize, I did not get that file this morning.
Okay. And I take it that this probably hasn't been provided to the district attorney at this point, correct?
No, sir, it has not.
Okay.
I tried to get here early, but I was not able to facilitate that.
Okay, so Mr. Sullivan, at this point, I just received these today, and so, I'm happy we'll put them in the court file. We'll get a copy to the district attorney. They'll have an opportunity to respond if they wish, and then I'll issue a ruling on these.
Okay.
We're going to get this set over for a pretrial readiness or pretrial conference in about a month, maybe a little bit longer. And you'll be back at that point in time, and by that point, I'll have rulings on both these things
Thank you very much.
in advance of that.
Yes, sir.
I guess the only other thing, Mr. Sullivan, that we need to address, certainly you have a right to represent yourself. And so if that's what you want to do, you certainly are entitled to do that. Your other option is if you want to apply for a public defender, we can get you an application for a public
I'll
defender.
represent myself.
Okay, fair enough. And then the only other thing that we need at this point, we do have a fingerprint order for you. And I'm going to...
Oh, no, I won't be doing that.
So
Absolutely
Mr. Sullivan,
There's not,
Mr. Sullivan,
unless there is a written.
Mr. Sullivan, this is
Yes,
my
sir.
time to talk, please.
Okay.
There's a fingerprint order right there. I'm going to order that you complete that by the end of next week and get your fingerprint submitted. Okay. If you fail to comply with the fingerprint order, you could be held in contempt of court. Okay. And so my expectation is that you'll comply with that court order.
That fingerprint order, Your Honor, is assuming that I have committed a crime and a criminal offense.
Mr. Sullivan,
Why would I go get fingerprints if there is no accuser that has come and said I've done anything wrong to any other human being?
Yeah. So Mr. Sullivan, that's the
By
order.
the Constitution of the United States.
Mr. Sullivan, that's the order of the court, and so it's up to you whether you
That's
comply or
fine.
not.
I'll send a writ up to the higher court and we'll squash that order.
The word you're desperately looking for is quash. In court, judges quash orders, they don't squash them like cartoon villains stomping grapes. And higher courts don't magically erase rulings because someone rambles hard enough about sovereignty. They vacate, reverse, or remand decisions through the actual appeals process. When you use completely incorrect legal terminology while pretending to understand the system better than everyone else in the courtroom, you're not sounding intelligent or rebellious, you're just proving to the judge, the attorneys, and everyone watching that you have absolutely no idea what you're talking about.
Okay, so that's the order of the court at this point in time. Ms. Davenport, any need for any sort of protection orders in this case? I don't see.
There's no damaged party, so there's no protection
I
order.
will issue the standard Title 18
Thank you,
protection
Your
order that prohibits you from harassing, intimidating, or interfering with any named witness or victim of the crime you're alleged to have committed. Okay,
Okay.
and we'll just get you a copy of that to sign, and I'm going to order that you sign that before you leave the building today.
I don't understand what the protection order is there for if there's been no one
So-
harassed. There's no person. There's no living person that's bringing the claim. So what am I getting a protection order for?
So, Mr. Sullivan, I just told you the terms of the protection order.
But who is it against? Who?
Any witness or victim of the acts you're alleged to have committed.
There is no witness or victim.
Okay. Well,
Look
then-
in the paperwork.
well,
There's
then
no
you-
witness or victim.
Well, if that's the case, then you don't need to worry about it. Okay.
Then why would one be
Um,
issued? I
And so, and then we're going to get this set over.
I mean, Your Honor, I don't think you'd be violating your oath of office by doing your duty by the Constitution. If there is no damaged party, there's no written affidavit with a competent fat witness, there is no charges here, sir.
Yep.
Yes.
There are charges, Mr. Sullivan.
But how? The state cannot bring charges against me. You're an artificial person. You're creation of the mind only, the government. I'm a living man based on the Constitution of America. You know this is true. I'm asking for a dismissal unless you can give me a damaged party or a competent fat witness with them with a written affidavit of what I have done to them. This case is dismissed.
So, Mr. Sullivan, I accepted your motion to dismiss, and I'll issue a ruling on that. Okay, and we're going to set you for a pretrial conference at 10 a.m. on November 25th. Okay, so sign the protection order.
So your
fingerprints done by the end of next week, and I'll see you back on November 25th.
So I need to know before I leave. I need that my Nisi Prius. I need that file. Did you put that on record?
That is in the file. That's correct.
Did you put it on record? It's in the file on record.
We've got it filed. Yep, it's in the court file.
Are you abiding by that?
Mr. Sullivan, I told you I would rule on the documents that you submitted. I just had them. I just received them 2 minutes before the hearing, and so I will issue rulings on those documents.
Where's this?
Okay, I'll see you back on the 25th. And have a good rest of your day, Mr. Sullivan.
And that wraps up the first hearing. But before we move on, take a good look at the way he limps out of the courtroom like reality itself just hit him with a steel chair. That's the natural consequence of stuffing your brain with too much sovereign citizen nonsense until basic logic completely stops functioning. The confidence is gone, the fantasy is cracking, and somehow it only gets more chaotic from here. So now, let's head into his next court appearance and watch this disaster continue unfolding in real time.
I'll call case number 2025 M534. This is People of the State of Colorado versus William Sullivan. Okay, good morning, Mr. Sullivan. So, you feeling any better?
No, I live with it every day.
Yeah.
So I get this ankle fusion. So.
Sure. Okay, well, Mr. Sullivan's here, and then we have, who's here on behalf of the people?
That's Ms. Ramon.
And Ms. Ramon's here on behalf of the people. So we were here in court last on the 15th of October. Mr. Sullivan, at that point in time, you indicated that you wanted to move forward representing yourself.
Correct.
And I ordered the fingerprint order, and I appreciate you getting that done. Thank you.
I got that for you.
Thank you. So I do see that the discovery's been made available through the district attorney's office. Have you had an opportunity to get that yet?
I had not had an opportunity to get that, and I just recently, because of some clerical things with Colorado, it took me a while to get a lot of my documents in place and notarized.
Okay.
And then I got to get a couple things authenticated from the state so they can have their commercial weight and value. So if I can get a continuance, that would be really great. I would appreciate it.
Okay. Have you had an opportunity to talk to the district attorney about possible resolution?
I don't have contact information from Mr. Sullivan.
No, I haven't. That's I possibly will in the future when I go to pick up my discovery.
Sure.
I guess I can just call the office and.
I have.
Sure.
We can discuss contact.
Well, Mr. Sullivan, I think here's kind of the way I envision this going. I'm willing to set this out one more time for a plea hearing.
Yes, sir.
And then at that hearing, I'll expect entry of a plea either way. If you plead not guilty, we'll get a trial set.
Right.
And if you reach some kind of a disposition, then we can go down that road.
Right.
But obviously, we've got to keep these things moving.
And I want to handle it properly on how I'm handling things. And just make sure all my ducks are in a row. So
absolutely,
and everything.
Absolutely.
Your Honor, I believe Mr. Sullivan also has a revocation of probation pending, 24 T13.
Oh, this just keeps getting worse for him. Not only is he now dealing with a fresh set of criminal charges, but he also managed to get his previous probation revoked, which means the court can pile even more jail time onto the disaster he already created for himself. At this point, his legal situation is collapsing from every direction imaginable. And honestly, after allegedly taking out highway equipment and then failing to report it, I'm pretty sure the light poles aren't exactly lining up to testify in his defense.
Yeah,
that court date's on the 23rd.
We set that on the 23rd.
Sir.
We can set this at the same time. I understand that's going to kind of crunch you for time in terms of being able to enter a plea. I mean, it makes some generally
I
run
have
these
some
things.
filings I have to make and to the Secretary of the State, and then get some documents authenticated from them. So that may take a couple more weeks.
Okay.
So it'd be nice if I could.
Why don't I
push
give
it
you a
out.
little bit more time
That
in this
would be-
case?
I would appreciate that.
I mean, understanding that, well,
We can set them off for like a longer period of time. I just want them to be set together.
That would actually be really beneficial.
okay.
That way I could handle it both at the same
Sure,
time.
sure.
You know what I
Let's
mean?
do that. So what's the revocation case, Mr. Muller?
24T13 is what I have in my notes.
Okay. So what we're going to do, I'm going to call case number 2024 T13 at this T13 at this point. Let's get these both set out. We'll set for hearing on probation January 20th. Does that give you enough time, Mr. Sullivan?
Yes, sir. I think I can accommodate that.
Okay.
Absolutely.
January 20th at 9 a.m. We'll set both these cases. So we'll set 24T13 for hearing on probation and 25M534 we will set for a pretrial conference or for a plea hearing. I'm sorry. Okay.
Set at 9 a.m.
9 a.m.
Thank you.
Okay. Sounds good.
Have a good
Thank
day.
you. Yep. Yeah, you too.
Alright, so that wraps up the hearing, with the court setting another appearance date for late January. But in the least shocking twist imaginable, he decided not to show up at all. Because apparently, in sovereign citizen fantasy land, ignoring court dates is somehow supposed to make criminal charges disappear. In reality, all it does is make an already terrible situation even worse and convince the judge that you have absolutely no intention of taking the process seriously.
Next, I'll call case numbers 2025 M534 and 2024 T113, People of the State of Colorado versus William Sullivan. Mr. Sullivan here. Give me just a second here. Okay, so I've got a minute order that indicates that Mr. Sullivan apparently called and said that he didn't have a ride to court and that he also had a sickness. At this point, I'm going to issue bench warrants in these cases. In case number 24 T113, we were set for a hearing on probation. Bench warrant will issue. Bond will be set at $1,500 cash surety. And then in 24 T113,
I'm sorry.
I'm sorry, in
25M.
25M534. That case bond will be set at $500 personal recognizance. Okay, anything else in these matters?
Nothing from the people.
Okay, thanks.
So, after skipping court entirely, he officially earned himself a spot on Montezuma County's See Him and Arrest Him list, which is about as predictable as this saga gets. And here's the worst part for him. Even though he technically had a bond, it probably won't mean a thing once he's caught, because violating probation while failing to appear almost guarantees a no-bond hold. In other words, he turned a bad legal situation into a full-blown self-inflicted disaster. But that's going to do it for today's video. Trust me, I'm keeping a close eye on this train wreck, and the second this guy shows back up in court, I'll be there to cover every ridiculous moment for you guys. So if you enjoyed the video, make sure to hit the like button, drop your thoughts in the comments, and subscribe with notifications on so you don't miss the next courtroom meltdown.